And we'll start in Pretoria. The High Court there currently hearing former Public Protector Busisiwe Mkhwebane's urgent application against the Public Protector's office, which she says was supposed to pay her multi-million rand gratuity. However, the office, which is headed by Advocate Kholeka Gcaleka, contends that Mkhwebane is not entitled to this payout. Mkhwebane was impeached from office last year, you might remember, for misconduct and incompetence following a Section 194 parliamentary inquiry. As you saw, those proceedings have begun with Dalimpofu for the former Public Protector speaking. Let's listen in.
It was said that judges and those people named there should not be put in the position, like all of us, where they have to bargain for their employment contract with the executive, as it were, for obvious reasons, which have to do with independence. And therefore, the Constitution saw it fit to prescribe a method by which their quote-unquote employment contract will be determined. In the case of judges, and this whole service conditions is replete with references to judges. Salary is equal to that of a judge of appeal, a motor vehicle judge of the Supreme Court, and so on. 8.3, subsistence allowance payable to the spouse of a judge of appeal. 8.5, allowance payable to a judge of appeal. So the law, the reason why there is this relativity between a public protector and a judge is because the underlying concept is the same, which is the concept of the independence. Otherwise, the public protector should have just gone to negotiate.
I don't see there is combination
with that.
The public protector, the person holding that office, is entitled and is required.
Yes, no, my lord. No, neither do I, quite frankly, knowing my learned friends. But I'm making a separate point. I'm saying that one of the, because remember, at some stage you have to look at the purpose of this. I'm saying one of the key issues under purpose is that issue of independence, and I accept your lordship. I'll take that as granted. Yeah. So it is indeed a contract of employment, my lord. But I'm trying to explain why a contract of employment. Why would a constitution of a country worry itself about a contract of employment? Because it normally wouldn't, but it does so because of this notion, this underlying notion of independence. So those people are in a special category which constitutionally their employment contracts are prescribed by law, so that to save them from the, I don't want to call it embarrassment, the inconvenience or the legal separation of powers problem of having to negotiate with the executive. Now, so my short answer to your lordship's question is that for the purposes of this case, we look at the service conditions as the employment contract. Right. Now, but obviously, as employment contract sui generis, which flows from the flow chart that I explained earlier. Now, if you do that, my lord, then it will be easy to understand that the Basic Conditions of Employment Act applies here, because we know that the Basic Conditions of Employment Act applies to everyone except those people who are excluded from it, such as members of the intelligence services and that kind of thing. And so that's the one thing. The other thing, my lord, is that, so your entitlement to remuneration, as from Section 32 of the BCEA, is just your entitlement like anybody else, except for the excluded people. The second important provision of the BCEA in that context is the one that says, my lord, that for all intents and purposes, the provisions of the BCEA are the minimum, that's what's called basic conditions of employment, are the minimum threshold below which no contractant can sink. In other words, if the basic conditions of, and I'm just making a wild example, if the basic conditions of Employment Act says you will have 20 days leave as a human being, you can't then contract and say, you can't contract and say, no, you'll have 10 days. But you can contract and say you'll have 30 days. That's no problem. But if...
The BCEA defines remuneration.
Yes, it does. I'm coming to that, Mala. I'm coming to that just now. But I'm just... I'll go immediately to that. If your lordship can just bear with me here. The point I'm making now is that the Section 4, I think, of the BCEA says a basic condition of employment, which is the same thing as a service condition, you can call it what you want, or employment contract. The label doesn't matter. But a basic condition of employment constitutes a term of any contract of employment. We've now established that that's what we're dealing with here. Except to the extent that a term of the contract or employment is more favorable to the employee than the basic conditions of employment. So in simple language, that means what I was just saying. You can't contract for something less than what the BCEA gives all and sundry. Now, if your lordship goes to, sorry. If your lordship goes to the 02-1, sorry, my lord, yes, -5. Oh, okay. I see where the confusion is, because of some historical reasons there were two supplementary affidavits. Sorry, my lord. The definition of no, the first thing. The definition of remuneration, my lord, is not something really esoteric. It actually covers the same ground as its quote-unquote definition in the Constitution. Yes, and there's no mention of car allowance. There's no mention of transport allowance and so on.
In context, the minister, sometime in the past, published a determination in terms of this act, in terms of Section 35(5).
Yes, ma'am.
And I will read it to you as to what it says. the Minister of Labour has determined in Government Notice 691 dated 23 May 2003 that
691, my lord.
691 dated 23rd May 2003 that the following method of calculating employees' remuneration for the purposes of annual leave in Section 21, payment instead of notice in terms of Section 38, and severance pay in terms of Section 41 of the Basic Conditions of Employment Act shall be effective from the 1st of July 2003.
Right.
And then what I wish to draw your attention to are the following. In that determination, in Section 1 or Item 1, it reads as follows. The following payments are included in an employee's remuneration for the purposes of calculating pay for the annual leave in terms of Section 21. Payment instead of notice in terms of Section 8, and severance pay in terms of Section 41. And then for what I wish to you to comment on is Item 2. And then it says, the following items do not form part of remuneration for purposes of these calculations. And in sub C, it says gratuities, in parentheses, for example, tips received from customers and gifts from the employer. So a distinction seems to be made there as between what constitutes remuneration and how that relates to gratuities.
Yes, my lord. My lord, you see, that's exactly the point I was making about taking a word out of its context. So surely, nobody is going to argue that the gratuity that is prescribed here from the statute or sub-statute or whatever you call it is equivalent to a tip given to someone in a restaurant.
Well,
although both...
Forgive me, I read this to mean that a tip is an illustration, but the point of substance is gratuity.
Yes, but that's the point, my lord. I'm saying if you accept that that's an illustration, it should at least tell you one thing, that there are gratuities and there are gratuities, and that one of them falls under the tip, which is why the that is given in that notice. But I'm saying that the and another gratuity might be the one to do with donations tax. But I'm saying that gratuity in relation to a term, a contractual term where there is a prescribed formula cannot be equated to a tip. That's the point. So in other words, that's what your lordship has just read exactly shows that there are, what shall we call it, categories of gratuities, starting from the mundane to the legislated serious type. That's exactly the point that that demonstrates. Now I'm saying, let's come back here and leave the restaurant to in the current context, my lord. I'm saying that the gratuity that we're talking about is the same as that of a judge, right? Now, and so I could be.
I think you mean to say that as in the person who holds the position of command,
Yes.
the person holding the position of protector also is entitled
To a similar kind of gratuity.
to a gratuity.
Yes, which is not a tip. I'm saying that it's more akin. If you had two gratuities, one is a tip and the other one is a judge's salary, the one that is more akin to what we're discussing in this case is the one of the judge. That's the only point I'm making. So and why do I say that, my lord? I say that because remember the real underlying submission of the other side is that this is a discretionary, as I said, benevolent thing that you do if you like and you don't do if you don't like. There's no legal obligation. Your Lordship correctly characterized. That's really the submission. It's so. Now I want to demonstrate to Your Lordship that the gratuity we're talking about here actually carries a legal obligation. Right? So let's go to page 6 of the manual, the second manual bundle, the one underneath, the one with statutes.